am the Director of Career Services at Indiana University Northwest.
And I'm Tawana Jackson. I'm the Director of Security at Ameristar Casino in East Chicago, Indiana.
So today we have a fabulous presenter. He is going to provide us some excellent insight in regards to understanding current attacks on diversity, equity, and inclusion.
So I'm going to share a little bit about Dr. Brown. It's so extensive we had to really limit it, and then he's going to add to it himself. So Professor Brown was on the faculty of Indiana University Mars School of Law for 35 years, from 87 to 22. He joined the University of South Carolina School of Law as a Mitchell Willoughby Distinguished Professor on the 1st of July of 22. His parents are school teachers, educated through Indianapolis, Indiana. Professor Brown graduated with distinction from Indiana University Kelley School of Business, where he majored in accounting. He spent his first year of law school at IU McKinney School of Law, transferred to, graduated from Yale School of Law in 1982. Upon graduation, he joined the Indianapolis law firm of Baker, Daniels, until 1987. Without further ado, and thanks for everyone for coming today this morning, Dr. Kevin Brown.
I'm going to add a couple of other things to the bio, but I need to start by thanking my wife, who. Oh, okay, there she is. Okay. Because believe me, she did yeoman's work to get me here today. We didn't get in until 2 o'clock in the morning, and that's only because she waited in the airport for me for 4 hours and then drove me up here. So, you know, she's certainly the power that drives me. So thank you very much. A couple of other things to just add that are relevant for this conversation. So I was also one of the original participants in the critical race theory workshop that took place in Madison, Wisconsin in 1989. So virtually all of my research has been in the area of race and law, and a lot of it in race law and education. So I've been doing a lot of talks on this for a very long time. And as we go through this, as a law professor, because we in the legal academy, as well as the American Bar Association, have really been stunned by the things that President Trump has done. He is not a king. We do not have a king, we have a president. And if you were doing something that was legal before January 20th, the president can't come and execute an executive order to make it illegal on January 21. So we are really struck in that we've never really faced a president who has denied the rule of law to the extent that we've seen over the last 6 weeks. My charge was to talk to you about the current state of the nation regarding inequality and the effects of the new administration. So what I'm going to do is I'm going to first go through the history to show how we got to where we are today. And then after that, what I'm going to do is talk about the 5 major developments impacting DEI and go through each one of those. And time permitting, I'll do a little more, but we'll see. I will say, and I have done this talk with the Urban League for the past 3 years, where I actually talked about critical race theory. And one of the things I pointed out in critical race theory is one of our major breakthroughs was the realization of just how oppressive colorblindness can be. Now let me be clear on this. I don't mean with friends, right? I've got, my friend, I don't think of him as white Ken or Puerto Rican Luis or South Asian Jay, right? They're individuals, right? So as individuals, we've got to know each other as individuals. But when I'm talking about using colorblindness in a context of political, legal terms and decisions to resolve racial conflicts, there are several really significant disadvantages and problems in colorblindness. If I have time, I'll talk about that a little more, but at least you'll see that all of these issues and these 5 major, I guess you could call them attacks on DEI, are really the unfolding of colorblindness. And it really should allow you then to really understand how that as a concept can really reinforce inequality, indeed freeze it into place. Now I also recognize this is a time of great confusion with respect to DEI. And my short answer to you is that the confusion is going to be there for a number of years. Right? I mean, you're seeing courts slowly adjusting to executive orders, striking them down here, striking down there. As I said, simply put, the president can't change the law. The president's job is to enforce the law. Congress, the legislature, is the one that changes it. So because of that, there's only so much confusion I'm going to be able to dispel. So let me start by discussing how we got to where we are. And on that then, there's no question that our conversations about DEI are rooted in our society's desegregation era that starts in the 1950s, particularly with the Supreme Court opinion in Brown versus Board of Education in 1954 that strikes down segregation in public schools. But if I update it to today, what I wanted to do was to give you the current racial and ethnic breakdown, and I decided to focus primarily on the young because so much of this is about education. So this is the current breakdown of our population under the age of 18. And as you can see, we're already a majority minority nation for those under 18. And if you think about our college age population, 54% of them right now are white. So to a certain extent, attacks on DEI seem a little irrational given the change in our racial and ethnic diversity that's already occurred. Okay, now you're gonna have to go with me. I know Americans don't like to talk about history. It is really endemic in our culture not to talk about it. But for me to really talk about the current DEI debate, I have to talk about history, particularly the Civil War. Which means, yeah, that's right, I did say the Civil War. Because as I go through this, you're gonna see that there are 3 major federal schemes that are involved in these attacks on DEI. And mostly what we're dealing with is reinterpretations of the original meaning of those. And those schemes are going to be Equal Protection Clause of the 14th Amendment, which was added to our Constitution in 1868, the 1866 Civil Rights Act, and then the 1964 Civil Rights Act. And what, there they are. Okay. And what does that mean? To say I need to go back to the Civil War means, and I assume you know about the Civil War, but what I really need to drive home is the impact of the Black community to holding the Union together. Because you don't really understand what happened at that period of time if you don't understand the significance of the Black community's contribution to maintaining our Union. Because that's one of the reasons we're going to end up with 3 different constitutional amendments and 5 major civil rights actions that are going to be passed after the Civil War. So looking briefly at the history, and it's really rather striking, there were full 205,000 Black troops who fought for the Union and the Navy during the war. A full 10% of the Union war dead were Black troops. The casualty rates of Black troops were 40% higher than white troops. And by the end of the war, Black troops constituted 13% of the Union Army, i.e. 1 in 8, and 20% of the Union Navy, 1 in 5. It turns out that a full 75% of eligible black males in the North fought for the Union during the war. And in addition, there were 200,000 other black people who fought in non-military capacities for the Army, meaning roughly about 1 in 6 black adults was directly involved in the Union war effort to abolish slavery. Indeed, both Lincoln and Grant will say repeatedly, without the black troops, we could not have won the war. Which, to paraphrase one of Lincoln's other talks, I think would be accurate to say, when government of the people, by the people, and for the people was about to perish, it really turns out to be the black people who saved it. And that then helps to explain why we ended up then with 5 major civil rights actions between 1865 and 1877, but the U.S. Supreme Court will effectively deliver opinions over the next 30 years, the last 3 decades of the 19th century, that will literally gut those civil rights acts. And the same with the 3 constitutional amendments, the courts will do the same there. But the first understanding of the purposes, and I can't stress this enough, so let me stress this. I'm going to take you back to what most of this is about from a constitutional standpoint, and that is the Equal Protection Clause of the 14th Amendment. Okay, this is the amendment which was ratified in 1868. And when the Supreme Court first addressed this amendment, this is what they said the purpose was. No one can fail to be impressed with the one pervading purpose found in the Reconstruction Amendments 13, 14, and 15, lying at the foundation of each, and without which none of them would have even been suggested. We mean the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made free men and citizens from oppression of those who had formerly exercised unlimited dominion over it. Now, with respect specifically to the Equal Protection Clause, this will be the provision that the Supreme Court will use in the summer of 2023 to strike down affirmative action. But in 1873, this is what the court said about the Equal Protection Clause. We doubt very much whether any action of a state not directed by way of discrimination against Negroes as a class or on account of their race will ever be held to come within the purview of the provision of the Equal Protection Clause. It's so clearly a provision for that race and that emergency that a strong case would be necessary for its application to any other. If this is rationales for our equality laws had held, there would be absolutely nothing wrong with DEI programs with considering race as a way to attack continuing racial equality that is rooted in our past. But, as I said, the Supreme Court will, by 1900, undercut these 5 civil rights acts as well as the 3 constitutional amendments, although, footnote, the Supreme Court is going to revive the Civil Rights Act of 1866 in 1968. So that act actually is still one of our important civil rights acts. It's just that you're going to hear me talk about it in a completely different context and being used for a completely different purpose than originally it was understood for. So what then happens after the court more or less undercuts these equality amendments and acts? They lay dormant until Brown versus Board of Education in 1954. And Brown versus Board of Education is the case where the Supreme Court will strike down segregation statutes that cover 21 states, 40% of America's public school students at the time. And that opinion then revives the Equal Protection Clause. But with that revision, we now are going to have a new question. Will the original purposes of the Equal Protection Clause and the Reconstruction Amendments survive this period of dormancy? Or will a new purpose be added to it? And that particular question got addressed in the 1978 case of Regents of the University of California versus Bakke. This was the Supreme Court's first affirmative action decision. But by the time you get to 1978, we also have the 1964 Civil Rights Act. Title VI of the 64 Civil Rights Act prohibits discrimination by companies and governments that receive federal funds. So whereas the Equal Protection Clause applies only to government, Title VI applies to even private corporations if you receive federal funds. So in the Bakke decision, one of the things that the court will decide is that the test for racial discrimination under the Equal Protection Clause will be the same for Title VI. So what is considered discrimination by government is also considered discrimination by private companies that receive federal funds. This opinion then is an opinion where we have 9 justices on our Supreme Court, and the Bakke opinion is probably one of the most significant opinions in our history. We have 9 justices. 4 of the justices, the question here is, could the medical school reserve 16 of its 100 places of admissions just for minorities? That was the question the court had to address. And the reason it was 16 in 1978 is 16% of the population were minorities. So, you see the relationship here. 4 of the justices said, no, you can't consider race in admissions at all. 4 of the other justices said, we agree with the original purpose of the Equal Protection Clause, and there's absolutely nothing wrong with a medical school reserving 16% of its slots for minorities. That meant that the decision about affirmative action rested with one of the 9 justices, Justice Powell. And Justice Powell's opinion is really the cause of the attacks on DEI today. So to a certain extent, I'm saying this was baked in as early as 1978. First thing that Powell had to do, Powell had to decide, did the original opinion and the original purpose of our equality laws survive? And the answer he gave was no. That you cannot turn the clock of our liberties back to 1968. It's far too late to argue that the guarantee of equal protection to all persons permits the recognition of special wards, meaning black people, entitled to a degree of protection greater than others. So he reconstitutes the purpose. He effectively amends our Constitution to say that the Equal Protection Clause will be there to protect the rights of individuals. And this is where colorblindness comes in. Colorblindness comes in this concept of individuals. The other thing then that Powell does is he has to address the rationales that are put forth by the medical school for reserving 16% of their places for minorities. And he's going to reject 3 of the 4 rationales they put together. The first rationale they put together is historic deficit of traditionally disfavored minorities in medical schools and the medical profession, right? Clearly, minorities were underrepresented in the medical profession. So here's the medical school saying we need 16% spots in order to deal with that underrepresentation. Powell says no, that's not a legitimate justification. A second is to counter the societal effects on under-resourced racial and ethnic minorities. You know, if I pulled out any of the racial disparities in important socioeconomic statistics, you'd see it. He says, no, that's not a rationale or not a justification either for considering race. The third, he said, was increasing the number of physicians practicing in underserved communities. He rejects this two. The reason he rejects the first three is because he's just said the purpose of the Equal Protection Clause is to protect individuals. Well, you don't know that you have an underrepresentation of minorities in the medical profession unless you look at people in terms of racial and ethnic groups. But of course, he's just rejected that, so if you look at them as individuals, you have no idea, because individuals don't give you group statistics. And that's the same with number 2 and number 3. The only rationale that he accepts for considering race in the admissions process of medical schools are the benefits of diversity. And this is why DEI programs are DEI programs, because Powell said it's only the benefits of diversity that you can use when you're thinking about including race in college admissions. Now, Powell only wrote for himself. And I guess the other thing I should say about Powell's opinion, the other thing Powell does is he rejects quotas. But instead he says you can use race and ethnicity as a factor that differentiates individuals. So his whole notion is that race and ethnicity could be used to differentiate individuals, means it's a positive plus, but it can't be used as an absolute bar. And then hence rejecting quotas, but race can be a factor in admissions. The next thing that happens of real significance is that the Supreme Court comes back to the issue of affirmative action in 2003 in the opinion of Grutter versus Bollinger. This opinion really deals with an affirmative action program by the University of Michigan Law School. This is going to be the decision that's going to lead to the significant expansion of diversity programs. Because by the time we had gotten to 2003, there was serious debate about whether or not you should be considering race at all in colleges, university admissions. But in 2003, once again, this time you have a 5-4 opinion upholding affirmative action. But in the opinion, Justice O'Connor also lays out the benefits of diversity. And she points to them here. The benefits of diversity in education is it promotes cross-racial understanding, helps break down racial stereotypes, enables students to better understand persons of different races, right? All the things that we think about diversity doing. Classroom discussion is more livelier, more spirited, simply more enlightening. It helps major American businesses competing in the global marketplace to have employees with skills that deal with diverse people. It actually improves the military. And that was really a very significant one, because this is a 2003 decision that was rendered 18 months after the Twin Towers fell. And it provides a set of leaders that have legitimacy in the eyes of our citizenry. So really with this rationale, we see an explosion of DEI programs because it has the imprimatur of the Supreme Court with the specific benefits that are now generally accepted. And then we all remember the extrajudicial murder of George Floyd caught on TV on May 25th, 2020. And the reaction to that was an incredible expansion of DEI programs. But what that expansion then did was to trigger a counterattack, an anti-DEI backlash. So that actually by the time we got to the 2020 election, that backlash was already in place and moving forward. Okay. So that's how we got to where we are. So I'm sort of giving you the background to get to where we are now, where we are. Okay, I'm not going to lie. Even my head is spinning because we're dealing with so many changes coming so quickly. So what I'm going to focus in on are 5 major areas or attacks that one needs to consider. So the 5 I'm going to talk about, one will be the Supreme Court summer 2023 decision striking down any consideration of race in the admissions process of selective higher education institutions. This is significant because this is the first time that the Supreme Court will reject the concept of the benefits of diversity. So it gives anti-diversity proponents a tremendous benefit that before had existed with people who were DEI proponents. The second is the February 14th Department of Education colleague letter. Okay, and if any of you read it, okay, it was chilling. Now, it was so chilling, and of course all of us as law professors went, well, this is absolutely insane because they've gone way beyond the law. And then on last Friday, the 28th, the Department of Education pulled back on that letter substantially to get it more consistent with the law. But that letter will apply to all educational institutions. Although, as you know today, we're also hearing that the DOE is going to be dismantled, so you can sit there and go, well, who's going to enforce this letter anyway? And yeah, as I said, I can't clear up all the confusion. The third is President Trump's executive orders in January 20 and 21st, anti-DEI executive orders January 20 and 21st. And they apply to all recipients of federal funds. And we'll talk about this, but the major provisions of this have already been enjoined nationwide by a district court, so the litigation against this executive order is well underway. The fourth thing I'll talk about will be Indiana's 229, which seems very much destined to move its way through the Indiana legislature. It will apply to all state and local governments and corporations that receive money from the state. And then the fifth one is the Fearless Fund case. And I hate to say it, this is the one that scares me the most. Remember when I talked about the Civil Rights Act of 1866 and I said it would be one of the 3 provisions that we're talking about? The Fearless Fund case is a case dealing with the Civil Rights Act of 1866, which is now 42 USC 1981. But it is one of a very important one of our civil rights programs right now. It's just that this Fearless Fund case has reinterpreted it. And when I get to it, I think you'll understand why I'm really concerned. The second thing that's going to be complicated, and this is where I really got to ask you guys to zone in for me here, is I'm dealing with an audience of people and I'm not sure exactly who you work for. Okay. So we have 5 different measures I'm going to talk about, and these measures impact different public and private entities. So I need you to kind of go, okay, I need to listen. So if you're a state employee working at a public university, all 5 are going to apply. Now, if you're a college professor, there is at least some carve out for academic freedom for the professors in the classroom and when they're doing their teaching. If you're a public school employee, K through 12, all 5 apply. If you're a private education company that receives federal funds, all 5 would apply. That would be private colleges and universities for certain. If you're a private company, not in education, but you receive federal funds, 4 of the 5 will apply. The only one you don't have to worry about is, of course, the DOE letter. And then if you're a private company, but you don't receive any federal funds, but if you do receive state funds, the state's SB 229 would apply. But if you don't receive federal funds or state funds, the only thing you've got to worry about is 42 USC 1981. So you don't have to worry about the Trump order, you don't have to worry about the DOE letter, you don't even have to worry about the Harvard case. Okay, so those are the 5 categories. I'm going to go through each one of these one at a time. The first one is the Harvard affirmative action decision. This one is huge. This one is completely changing the makeup of our most selective colleges and universities. Basically what the court does here is they strike down affirmative action in admissions policies, a program that's been effectively in operation for over 60 years. They struck it down with a 6-3 vote. And there's no question that the reason it was struck down was because President Trump was able to appoint 3 justices. So it went from 5 justices to 4 that supported affirmative action to now 6 justices to 3 that are against it. And it is very unlikely that the Supreme Court is going to change its interpretation of affirmative action in the Harvard case, at least in the next 15 years. Because it is a 6-3 case, you would have to have at least 2 of the justices in the majority come off. And the oldest one there is Clarence Thomas, and he's 74. So really, I wouldn't anticipate any significant change there for maybe 15 years. And we were going to have to deal with this even if Kamala Harris had been elected. What Justice Roberts, who wrote the opinion for the majority, writes in there is he says that race cannot be used to disadvantage someone. Meaning, if you took race into account in order to help underrepresented minority applicants, you're harming other applicants. So he sees that as something colleges and universities cannot do in admissions. And he also says, and this is also striking too, that government cannot stereotype individuals. But what he says means stereotyping is if you simply recognize that someone is a minority, that is a stereotype. So if you say, hey, Kevin, you're black, oh, you stereotype me, because you said I'm not a minority. Oh, that's a stereotype. Okay. As I said, this 6-3 opinion is really a major, major problem, because remember, the whole point about why DEI is because of the Supreme Court opinion. Well, now here's the Supreme Court saying we are ourselves rejecting diversity as a rationale. And this opinion will apply to state and local governments that receive federal funds. And its impact on admissions is clear. That much we do know. It's really then gets debated, because right, we're lawyers. The whole point about being lawyers is you argue about stuff. So we can all agree, yes, it applies to admissions, but what about minority scholarships? What about overseas studies program? What about residential theme programs? Those are being discussed and being litigated. Different states are doing different things in this area. It's still an area very much up in the air. But I thought I would at least give you some sense of the current impact that this opinion has already had by showing you probably the best thing I could show you, racial and ethnic scores on SAT tests. And here they are. And if you do colorblind admissions, you can see that these test scores are going to start to dramatically shape who are the people at the most elite educational programs. Now let me quickly say, not all educational programs use any kind of affirmative action because they admit everybody who applies. And if you admit everybody who applies, or if you admit everybody who has certain academic requirements, you're not considering applicants on an individual basis, so you're not really worried about race and ethnicity. I will point to this growing gap on the SAT test scores between Asians and whites. Indeed, in the Harvard case itself, the argument was that if you use purely SAT scores and GPAs, 40% of Harvard's undergraduate students would have been Asians instead of 20%. Because I am in law, I have looked at the racial and ethnic makeup of the students that came into law school this fall. This fall was our first year in which the Harvard affirmative action opinion was in place. And you will see dramatic increases in the number of Asian students at our most elite law schools. I mean, I'm talking about 20, 30, 40, 50, 60%. Some schools even double their numbers of Asian students. For black students, typically what we saw was at the very elite schools, they tended, like the top 10, 15, tended to hold. But the rest of them, they were sort of redistributed down to the weaker law schools. This is another way to look at the SAT scores. Now, I understand these are a little dated, but I always thought this was a great graph, because you can see as you go up in SAT scores, the tremendous impact at those scores. And I can't leave without at least saying this. Most of us in law, we don't really think that these scores are that significant. We think that they're overblown. So in November, the American Bar Association, which determines what it is we as law schools have to consider in terms of admitting students, passed a resolution that said we can ask for waivers for all or some of our law student applicants. So law schools are going basically through a process now of getting waivers where they won't even require LSAT scores or any standardized test scores. I'd have to talk to you for a whole hour to talk to you about the bias in SAT scores, but that's, I don't have that kind of time. Okay, the second is the Dear Colleague letter from the Department of Education, February 14th, 2025. It applies to all educational organizations that receive federal funds, but it purported to be an interpretation of the Harvard affirmative action decision. And I want to point to this statement here, because this is what's in the letter. Although some programs may appear neutral on their face, a closer look reveals that they are in fact motivated by racial considerations and race-based decision-making. No matter the form, remains impermissible. They go on, relying on non-racial information as a proxy of race and making decisions based on that information violates the law. It would, for instance, be unlawful for an educational institution to eliminate standardized testing to achieve a desired racial balance or to increase racial diversity. That was directed specifically to the law schools. Now, let me try to explain how far that language would go. Don't get scared, because they pulled this back 2 weeks later, because no one would ever go that far. But if you actually took it that far, it would mean, of course, you couldn't have black student unions. You couldn't have black law student organizations. It would raise questions about black studies programs. You would even have questions about historically black colleges. We would have to worry about whether or not you can celebrate black history. And indeed, if I, as a black law professor, walk down the law school hallway and wave at a black student, that too would be considered a violation of what was in that Department of Education letter, right? But what else? You couldn't have celebrations for St. Patrick's Day, right? Because that's for the Irish. You certainly couldn't have Holocaust remembrance celebrations, because that's for a specific racial group. And I think once they began to realize this, they're like, okay, we don't really mean that. So forget all that. Forget that. It's not that bad. Okay, it's not that bad. It's bad, but it's not that bad. So they published then the letter 2 weeks later. And this is what they said. Schools with programs focused on interest in particular cultures, heritages, or areas of the world would not in and of themselves violate Title VI, assuming they are open to all students regardless of race. Nor would educational, cultural, or historical observances such as Black History Month, International Holocaust Remembrance Day, or similar events that celebrate or recognize historical events and contributions and promotes awareness, so long as they do not engage in racial exclusion or discrimination. Let's see what I have there. Okay. In other words, of course you can have Black student unions. Of course you can have celebrations of Black history, Black studies, Latinx studies. If you have these culturally themed programs, they would just have to be open to everyone. But of course the point is you want them open to everyone anyway, because that's right, that's the whole point. So this is not really a significant or major change from the current practice. The other thing that the DOE said in its February 28th letter is it recognized that by law, the DOE is prohibited from dealing with the content in school curricula. Oh, there you go. And recognizing that students, and to a lesser extent teachers, have First Amendment rights in schools. So they recognize that. And I would say what was really encouraging about the February 28th letter was that the first thing we really got from the Trump administration where we go, okay, they really recognize there is a law out there. They recognize they have to comply with the law. And I thought that was really encouraging. I had a conversation, I saw what Donald Trump said, you know, of course I sent these executive letters. I knew a lot of them weren't going to be held effective, but we've got 4 years to get them in place. And I thought, oh man, that's great, because it means he recognizes his term is only 4 years. Okay, and as I said, of course, we're also being told that they're going to dismantle the DOE, so that raises all kinds of questions about who's going to enforce this. The third, which is a big issue, is President Trump's anti-DEI orders. Now, they will apply to those who receive federal funds. But if you will recall, going back slightly before the 2020 election, he also issued an executive order that was intended to attack DEI's critical race theory, these concepts. And that order was enjoined 3 months later on December 22nd, 2020, for 2 reasons. One of the things that order attempted to do was to say to private companies, look, you shouldn't engage in DEI programs. And the response to that was, and this is what the court says, was there is this thing called the First Amendment freedom of speech. If I as a company want to talk about DEI programs, the government can't silence my speech. Now, it is true that the government can say you can't use government money to promote your speech, so they can say I can't do DEI in the programs that receive federal funds, but you can't tell a private company what they can do with their own money. So that was one of the reasons it was enjoined by the district court. The second reason, and this is something all DEI proponents know, what the heck is DEI? Right? I mean, we've tried to figure that out for a very long time. Well, the problem is if you're going to actually ban DEI, you need to be able to tell people exactly what it is that you're banning. And that was the second reason that it was struck down, is that the court said no one of common intelligence could really understand which programs were legal and which programs weren't legal. So it was enjoined. And then, of course, Biden withdrew it as soon as he got into office. So he has issued another executive order, as I said, the January 20 and 21st. And this, too, has been enjoined in the most important provisions February 21, 2025 by a district court on the same grounds. Right, you're on the same grounds of violations of freedom of speech and void for vagueness, meaning the Trump administration clearly knew that this thing was going to be enjoined, but it was enough to get the fear by issuing it out there. And I think they've been fairly effective in doing that. Indeed, I say this to people, it was striking, but I was actually headed to the University of Florida Law School to run a race and law center. And then the governor down there signed the Florida Anti-Woke Act. So I literally, that's why I'm in South Carolina, not University of Florida. But of course, the Florida Anti-Woke Act got enjoined as well on free speech grounds, academic freedom grounds, and of course, void for vagueness. And the void for vagueness is going to be an issue because it really is kind of hard to say if you're trying to ban a particular kind of speech, just exactly what it is you're trying to ban. And then of course, because it is speech, then you're going to have First Amendment problems for private speech. Now don't get me wrong, if you are a public employee, you do not have First Amendment freedom of speech rights when you are engaged in your official acts as a public employee. But they can't ban what you say during lunch, they can't ban what you say during breaks, they can't ban what you say before you come to work or after. Okay, and then this brings me then to SB 229. This bill seeks to ban diversity, equity, and inclusion initiatives in state government and public schools. And once again, state governments can't say what to do, can't put limitations on what they want their money spent on, as long as there are no improper motives. And this is going to have an impact. I don't think there's any question. It's going to have a big impact. Other than professors in state colleges, state employees, as I said, do not have free speech rights while performing their governmental functions. Right? In other words, this won't apply to me the same way as it would apply to non-professors, because it can't really restrict what I say in the classroom. That's a whole part of our academic freedom, and just simply put, right, the whole point of having people like me at universities is to critique the dominant wisdom of society, because that's the only way this society comes to learn that its understandings are wrong or need to be modified, is to have people who are critiquing it. And if you prevent professors from doing that, then you don't really have anybody who can critique it. Okay. God, this thing gets me to the Fearless Fund case, and this is the one I'm worried about. And you better be worried. This is an interpretation of the Civil Rights Act of 1866. It's now 42 U.S.C. 1981. And let me give you the facts of it. Well, let me first show you what it says, because as I'm saying, it's been reinterpreted. The act actually says, and if you go to 42 U.S.C. 1981, it will say, all persons shall have the same right in every state, territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws, proceedings for the security of persons and property as enjoyed by white citizens. Right? This was passed in 1866. The intent was to provide a way to prevent discrimination against black people. Okay. What now is being applied to everyone. And the Fearless Fund case. So here are the facts. The black community creates this program, the Fearless Fund program, to give $20,000 grants to black women entrepreneurs in IT because they are so underrepresented. Meaning the only people who can get the grants have to be black women. That is what was enjoined because it was limited just to black women. And it was a contract. And let me see if I can explain it. It would not apply if we're talking about a gift. But the argument here is that what 42 U.S.C. 1981 is understood as saying, you cannot discriminate against the making and enforcing of contracts. So if you're going to have a program like this, and indeed, let me give you the example I gave when I spoke to the 100 black men. I said, look, let's say you guys, the 100 black men, want to give a scholarship limited to black men, and they have to maintain a 2.5 GPA to keep it. This act, the way it's interpreted, would in fact apply, which would mean that then your program should not be racially exclusive. You need to open it up to others. You'll have to figure out how you're going to judge the applications, but you cannot limit the people who can apply based on race. And I would say even in law, we're really dealing with this, because a lot of law firms had diversity scholarships that were limited to underrepresented minorities. Well, those now really become questionable in a way that any of the other things that I've talked about, any of the executive orders don't. So this is one which is going to be an issue. Okay, now let me, I just, how much time do I have at this point?
The current time is 11:20.
Okay, so how much time?
20 minutes left.
I got 20 minutes. Okay, if I got 20 minutes, what do I cover in 20? Okay. All right. I got to do this because hopefully now you can really see what we were complaining about with respect to the concept of colorblindness. And I'm saying, within the legal academy, the number one effort that we will be trying to do is to try to return the law to where it was before the summer of 2023. We know that it's going to take, as I said, a change in Supreme Court, which means a minimum of 15 years. But the problem with colorblindness, is, take me. I am an African-American law professor. And believe me, race has shaped everything about me. Right? I mean, I was on an affirmative action program at Yale Law School. I was the second black person to work as an attorney at a major law firm in the history of the state of Indiana. I'm the longest serving law professor of color ever in the history of the state of Indiana. Everything really about me revolves around race. But if you're going to be colorblind, you literally ignore all of those things about me tied to race, which means whoever you think I am, okay, that's not me. But that's one of the problems with colorblindness, is it denies the experience of people of color that's shaped by race. A second is that it really then reduces the concept and the definition of racism, because racism only becomes when your actions are consciously and intentionally motivated by racial considerations. So it ignores things like stereotyping or unconscious racism or institutional racism. Those as concepts of racism simply do not exist within colorblindness. The only concept of racism that exists is individual, conscious, motivated discrimination. Another problem with it, what you want to know if somebody's black, ask them how often they think about their race, color consciousness, right? Because you grow up in this society being compelled to be conscious of race. But when you think about colorblindness, the notion is you're to transcend considerations of race. You are literally saying to black people, your entire way of looking at the world is racist. And we then become the racists. Another problem with colorblindness, individuals hate to be called racist, right? Right? It's a moral condemnation now, because you're saying something about me individually. And Ray, if you ever want to just destroy friendship, call somebody a racist. They'll never talk to you. The fourth thing is it discounts the importance of history. I mean, one of the reasons I went back to talk to you about the impact of the black community on the Union War effort is that that's not something we typically talk about. We don't typically talk about the fact that it was black people who saved the country, right? Because if you don't want to talk about history, you don't want to go back there and talk about those things. And if you don't talk about history, and then you look at the racial disparities that exist in all of our important socioeconomic statistics, you kind of go, well, there must be something wrong with those people. When in fact, the current disparities are clearly manifestations of our history of racial discrimination. Not that any of us are individually responsible for it, no question about that, no. But there is something that occurred in our society that is continuing to impact our society today. The other thing that colorblindness does is it institutionalizes the white majority's experiences as the norm. And that can be a tremendous advantage. And then finally, of course, and this is what we're finding out, if you take race into account, it didn't, to remedy the present effects of past discrimination, that becomes a new form of discrimination. And this was the one for us in critical race theory that scared us more than anything, because this means you're freezing in place the existing racial and ethnic disparities. And let me just, especially in this time where you're seeing all this anti-DEI movement, let me just remind you about the disparities. Black family income is about 66% of non-white Hispanic income. Black poverty rates about double that of white non-Hispanic. Black people, about 17% have college degrees compared to 26%. Unemployment rate for black people, typically twice that of what it is for white people. On home ownership, we've been about 44% for, at least the last 40, 50 years, compared to 72% for whites. Our life expectancy is less, although if you're black female, this is really good news because you've actually caught up with white females, so it's really black males who have the disparities. And of course, prison sentence. So, what should we do now? I'm gonna tell you, this really, as I've kind of laid this out, right, that's the whole thing about being a law professor, is I do recognize that our society is being shaped by law, even though the citizenry may not necessarily see it. Like I knew the expansion of DEI programs was coming from Supreme Court support of diversity. And then once they pull that support, that's going to have a major impact over a period of time that will unfold over a period of time. Just like the expansion of DEI programs after 2003 unfolded over a period of time. So my hope, I know the next 15, 20 years, and I'm hoping I'm being optimistic there. But you really got to resist rollbacks as much as possible, legally possible. Right. Law is the law, and follow the law. I'm not telling people not to follow the law, even if you don't like it, because you definitely don't want to get caught up in the legal machinery. But a lot of this is going to come down to individuals making individual judgments about what he or she should do. In other words, there will be certain discretion. And I would say to the extent that one can use that discretion in such a way as to further the benefits of diversity. But I've got to be honest on this. We're going to see a tremendous hit in terms of Black and Latinx professionals, medicine, law, accounting, engineering, the STEM field. Indeed, when I think of a lot of Black people who actually earn a lot of money, a lot of them actually are in the legal field. So those opportunities aren't going to exist as much, which is one of the reasons I suggest you put a more focus on entrepreneurship. Because we are going to see government significantly pulling back from DEI programs, you really are going to need more private organizations taking this up. They really have to come in, and to the extent that they can fill the gap, and I'm not saying they're going to be able to completely fill the gap, because this is really a strategy of eliminating the rollback so that when we come back to this, we don't have as far to come back. And boy, I tell you, maybe the biggest thing I can tell you is you got to make sure you vote for the right candidates. And I mean not just vote, but vote for the right candidates. Okay, obviously you can look at me and go, okay, this man must not have voted for Donald Trump. Okay, I'll admit it. Once you knew what he was going, if anybody paid attention, you knew what he was going to do. The one thing about Donald Trump, and this is the thing that kills us, is he wasn't hiding anything.
Absolutely.
So if this is not what you want, well, let me do it a different way. In our society, the real way to make fundamental changes in our society is through the political process. And I understand if you're Democrat in the state of Indiana, you're like, oh crap. Okay. But it doesn't change. You can't give up on the political process, right? There's certain levers in our society where you can make an impact, but there's no question politics is a major aspect of it. And then finally, I just threw this out here, and this is the NIL money. Man, I mean, you've heard about this already. The money that these college kids are getting on their own NIL deals. Okay, come July 1. And a lot of the money the college athletes have been getting has been the result of antitrust litigation against the NCAA. So as a settlement to one of the lawsuits, come July 1, the NCAA will provide $20 billion to colleges and universities for paying the athletes. Now here's a big one that no one's really started to talk about yet. The Biden administration said this $20 billion has to be split equally between male and female athletes. The Trump administration pulled back that guidance, which means you're going to start to see, particularly male basketball, football players, getting literally hundreds of thousands of dollars playing college sports. And we all know young kids with that kind of money gonna blow the heck out of it. So you really, I would think, need to develop some kind of group to help these athletes learn how to manage their money. And with that, I'm gonna stop. Okay, so there's any time for questions.
All right. So we definitely have time. Please, this is the time for question and answers. And then also we have a survey that we're asking all the participants to completely fill out on the front as well as the back, and then we will collect them. So please feel free to ask questions.
And I know you don't be like my students. Okay, I know if you had questions, because if you got a question, I can assure you other people here have questions too. And this is such a complicated time.
If you come up with the NIL, the image and...
Name, image, and likeness, yes.
Oh,
yes,
okay.
yes. And this is why Indiana University has the best basketball team money can buy. Not the best basketball team, just the best one money can buy.
As it relates to the money, when we talk about the NIL deals, what about this money being distributed amongst HBCUs as well as private universities, public universities? Has there been any distinction as it relates to that?
No, it'll all go. So they have a formula with the amount of money that's going to end up going to each university. Right, because my home is still Indiana University. Indiana's going to get an additional $20 million a year for its athletes. But no, it'll go to everyone.
My concern, of course, there's been, when you talk about DEI, the negative opinions as it relates to HBCUs, and let's face it, when it comes to sports, I think when Deion Sanders went to Jackson State, you start seeing I mean, because we weren't seeing HBCU games on national TV.
I would say one of the results of the Supreme Court striking down affirmative action, the HBCUs saw huge increases in applications. There's no question the HBCUs are going to get much stronger, not only because of students, but also professors who are saying, look, I mean, for example, I say I'm not teaching at Indiana University Minor School of Law now, but for the 35 years I was there, at least the last 30, we were bringing in from 10 black students to 20. Last year they only brought in 1. And black professors want to see black students too, so you're going to see a movement to HBCUs, and they're going to really start to get. I don't want to. I mean, they got great professors now, but the big difference is we're research professors. I mean, that's what's so great about Indiana is they provide me all this money and time to work on these problems and to think them through.
Excuse me, I have a question about the NIL. So, I haven't been in school forever or college, but what about the NAIA? Are they under there or is it only NCAA?
Yes, the NIL money, name, image, and likeness money, is only going to D1 schools. So it's not going to D2, it's not going to D3. Because if you think about the NCAA's money comes from the basketball tournament, and that's all D1 schools.
So, another question, the historically black colleges, aren't a lot of them NAIA?
Some of them are Division I, but a lot of them are not.
Right, okay.
The ones that are Division I will participate.
Okay.
It only comes from Division I schools, not the lower countries.
Correct. Because because the litigation was colleges and universities are getting billions of dollars with basketball and football, and they're saying that the athletes can't be paid for it. I mean, really, in a way, it was an anomaly where you had a situation where the employees were generating the money, but because of the structure of the sport itself, you couldn't pay them. So that's why the money's going to the D1 athletes. Yes, sir.
Not really a question, but I wanted to speak to what you said about how the DEI, like this current administration's attack on DEI, is going to affect kind of the job outlook in the future. You said something about leaning more towards entrepreneurship. The union building trade is an avenue that people should really look at for the next generation.
I agree.
Mainly because too, they get involved in politics in a sense because the Republicans really don't want to pay for top tier labor.
Yeah.
And so you can really, and unions used to be real big on nepotism, but now it's so many jobs out here and they can't man them, so they're looking to take them.
Yeah.
So they're willing to show up every day.
I think that's an absolutely great addition. Thank
you. Just a thought, I just want your thoughts on, you said 15 to 20 years, and that's because of turnover on the Supreme Court. That's our first,
And that's hope.
our long-term hope. Just wondering if everyone comes to their senses and elects a Democrat to the presidency next time, what are your thoughts on packing the courts? Or expansion of the courts?
The nuclear option.
You can come back to the question.
Okay, well, let me just my fear is that, okay, so you do it now,
Right.
and then Republicans get back in and they do it, and then you just, and so and I think if it was gonna be done, Biden would have come in with a plan to do it right away, because he could have justified it in a way it's gonna be harder to do later. If you think about what happened with Obama's last pick, Merrick Garland, and then what happened with Trump's last pick, both of whom will rush through. So you could make a sort of equity argument this time that it's hard to make most times.
So I had a question just around, the private sector kind of rolling back all of their DE&I initiatives, like the Targets, the Walmarts, the Amazons, all that good stuff. And from the executive order, it seems like a lot of this applies just to federal funding, or federal contracts, whatever the case may be. So I guess, like, your opinion, why would they kind of jump the gun so fast to roll back these initiatives? It may not really apply to them.
Anticipatory compliance. That's the term that's being used now. I mean, let's face it, not everybody was supportive of DEI. There were a lot of people who were against DEI. Obviously, the election of Donald Trump makes that clear. And then this, if you were against it, now you've got the shield. Well, it's not that I don't think it's good. It's illegal, and because it's illegal, we shouldn't do it. So I think that had a lot to do with it. I will say, at least if you do look at the studies on this, the studies do seem to show that if you really take diversity seriously and important for your employees, you have happier employees, less turnover, more profitability, better decision making. It all seems to be best for businesses. So I have no doubt that businesses are going to hold on to it. And as I said, the other thing is you're having this dramatic change in the workforce. As I said, under the age of 18, we are a majority minority country. I will say this too. I think a part of the backlash against DEI was the transgender issue. And let me be clear on this. The United States Supreme Court, with one of Trump's justices, wrote the opinion that said discrimination against transgender individuals by employers is considered sex discrimination. They have that protection, and historically, the Supreme Court has said what we say for Title VII applies to Title IX. So the cases about transgender kids in bathrooms, if you go and say, look, there's male, female, we're not recognizing transgender, that's clearly discrimination. And at least you've got a majority of the Supreme Court right now on the side of saying that is discrimination recognized by our anti-discrimination laws. So in a few years, we'll see the Supreme Court address that, and whether or not they back off on what they did in 2020 or not, we'll see.
I don't know if I missed the slide about the Indiana law that we're going to pass. I know you said at the beginning, and then this was great. Could you review that?
Oh, yeah. That was SB 229. And this is the bill that seeks to ban diversity, equity, and inclusion initiatives in state government and public schools. Generally speaking, state governments can make this decision. They can say, we do not want our state money used that way. And it does look like that's on its way to passing. Now, the only argument you can make is improper motives, and which means if you could prove that they were doing it for racially discriminatory motives, it would be invalid. Of course, the thing here is that they're saying, well, no, we're really doing this because of combating discrimination, so that the motives don't seem to be discriminatory. I will say there was a challenge in Arizona that turned out to be successful, where they went to eliminate the Hispanic curriculum that they had been using in Tucson, Arizona, and they were able to make the claim there, but I think it's going to be really hard here. So yeah, I'd say keep an eye on it. I don't think it bodes well for the diversity program. But then it's going to be a question of, well, what does it actually ban? I mean, as I said, right, I had lunch with the president of Indiana University a couple of weeks ago, and of course, we talked about this, and her notion was, look, we're trying to transfer these programs into non-racial areas. So it's not that we're going to get rid of them, and you almost can't, because as I said, you've got such a diverse student body, and not just racial and ethnic diversity, but DEI programs also include gender, disability, veterans, first generation, low income, and they make a lot of sense because you need to keep people happy to keep them with your institution.
Is there any correlation in
all of this DEI talk in the state wanting to steer away from Section 504 plans? Because that's huge.
Let me do this. Let me say, I'm gonna say, like, I'm gonna stay away from that. I'm gonna stay away from that only because I have not really done any work in disability. The only disability work I did deal with the IDEA, but I haven't taught law and education in probably 20 years. So
No, I was just curious.
I understand the notion about money and states and all. One thing is very clear to me. This is the reason charter schools are expanding. And that was always clear, was that charter schools cost less than regular public schools. And at least the evidence seems to show that charter schools are no more ineffective or effective than public schools, but because they cost less and parents like the ability to pick the school. I mean, this actually was my conclusion in my book 20 years ago. These things are going to spread for two reasons. The government officials like them because they cost less, and the parents like them because they can pick the school. So regardless of improvement in academic performance, those rationales are enough for them to spread. And I do think that is one of the targets of state governments to save money, but I mean, man, you know, not just there, but Medicaid, because a lot of Medicaid dollars are going to disabled people. Yeah.
So what did that have to do with charter schools and disabled?
Oh, it's just a way to save money.
Oh, okay.
I mean, that's really the charter schools is, we save money and the people won't be too upset.
So I just read that, I saw recently that Apple shareholders defied a request to eliminate DEI.
Yeah, right.
So is DEI just a transient issue, just a weird issue? Will it be around?
It has to be around.
I'm talking about anti-DEI.
There may be an anti-DEI movement. Let me rephrase. Clearly there's an anti-DEI movement. The problem is that it's running into the reality of the changing racial and ethnic makeup of American society. Now, you know, who knows if we do end up deporting 40 million recent immigrants, whether it's illegal or illegal, that might change the demographics. I can tell you, the issue on birthright citizenship, this thing is huge. Because while the Trump administration is saying, well, we're only going to apply that prospectively, if the Supreme Court rejects birthright citizenship, it undoes citizenship for tens of millions of Americans. And then there's going to be this big issue about should Congress restate that citizenship, and that'll become a huge political issue. But I guess that's what I'm saying is, you know, even if you hate DEI, half your workforce is going to be made up of racial and ethnic minorities, and that's not even including the gender component, the disability component, veteran component, foreign workers. So you need to really pay attention to it if you just want to be effective in whatever it is you're doing, whether it's education or business. Are you shutting me down? She said no. Okay. Any other questions, comments, thoughts? Yes.
I thought it was interesting. I recently saw a comment where it was saying that using DEI is kind of replacing the N-word. Because oftentimes you see it associated with minorities, specifically black people, they try to make the argument that the person isn't qualified for the position that they have.
Don't forget that's the reason the plane crashed.
But I find it interesting that what we're seeing with this current administration, people that are in positions aren't being put in positions because they're qualified. Take the FBI, for example. The director of the FBI as well as the deputy, no experience in law enforcement whatsoever, but you're running the FBI. Just interesting things that I've noticed. So.
when you're asking for consistency.
No. I'm just making a statement.
Okay, okay. I agree. I agree.
If that's the last comment.
When we get started on what I had to cut out.
Can I get a copy of that slide? Coach?
Oh, yeah. I always certainly give these to Dr. McLeod. I do that every year.
Okay.
You know, right?